This is Democracy Watch. I'm joined by my co-host, voting rights attorney, and the founder of Democracy Docket, Marc Elias. So, Marc, the Wisconsin Supreme Court now officially has a liberal majority with the swearing in of Judge Janet Protasiewicz. And immediately after her swearing in, we saw a lawsuit filed challenging the state's legislative maps. Can you speak about that lawsuit?
Yeah, the lawsuit tells us what we know, which is that the maps in Wisconsin are extremely gerrymandered, arguably the worst gerrymander in the country. And so it is good to see that Law Forward, our friends in Wisconsin, are seizing this mantle at this time to try to get fair maps in that state.
Now, I'd mentioned that this is a lawsuit filed against the state legislative maps. What about the congressional maps?
Yeah, so I think what happened here is I think Law Forward sensibly decided to bring this case first because the state legislative maps, 2/3 of the state legislature approximately are seats controlled by Republicans. This is a state that's 50-50. So the congressional map is also gerrymandered. It's a 6-2 map, 6 Republicans, 2 Democrats. So I wouldn't be surprised to see a congressional case brought also, but I totally understand and agree with the strategy of bringing this state legislative case first.
Could you explain that strategy? Like, why not go and bring both of these cases at the same time?
Well, so remember the backstory here, Brian, which is that the legislature and the governor deadlocked in the drawing of the maps, right? You had a Democratic governor in Tony Evers, you had a Republican legislature. They deadlocked in drawing the congressional map. They deadlocked in drawing the state legislative maps. The court at that point controlled by very, very conservative members, very conservative. They held that the starting point for the new maps, the new legislative and the new congressional maps, would be the old maps, which were very gerrymandered. And so Law Forward here, the plaintiffs' lawyers here, had to make a decision which case to bring first to establish that the state Supreme Court has the authority and will take jurisdiction, the good legal word, and sort of hear this case. So I think they started with the state legislative maps because they're very egregious, and also it doesn't involve any federal claims or federal constitutional issues. It's just a matter of state constitutional law.
So in theory, would this then, if the legislative maps are ruled, unconstitutional, that they're too gerrymandered and they have to be redrawn, would it then ostensibly be easier in a subsequent case for the congressional maps to then be redrawn?
I think that's right. I think that if the plaintiffs win this case, I'd be shocked if we don't then see a case over the congressional maps next.
Okay, now, irrespective of the breakdown of Wisconsin's Supreme Court, how strong is this case for the plaintiffs?
Oh, it's a very strong case. I mean, as I said, 2/3 of the seats belong to Republicans in a state that is 50-50. I mean, remember in the last election that we just had, Ron Johnson, the Republican, won by a little bit. Tony Evers, the Democratic governor, won. The Democratic attorney general won. Democratic secretary of state won. This is a 50-50 state. And so I think that they have a really strong argument that this was a partisan gerrymander. They also make a couple of other claims worth mentioning. One is they point out that a large number of the seats are not contiguous, which means that the land mass isn't all together, which violates the state's constitution. And that's a further sign at how much gerrymandering the Republicans had to do to keep this majority. And then the third claim is, as I said, the prior court, the conservative court, had started with the baseline as the maps that had been in place before, and then they adopted to implement that the map that was offered by the legislature. Well, the legislative map had been vetoed by the governor. So they make a very compelling argument that violates separation of powers for the court to essentially implement the legislative version of a map that was vetoed by the governor.
Now, you've mentioned that there are numerous instances wherein the state constitution was violated. So why was Wisconsin allowed to have this political gerrymander in place thus far?
Because the very conservative justices of the state Supreme Court, in the majority, 4 of them, ruled that it was so. And there's probably no court that is going to travel a greater ideological distance than in Wisconsin. The conservative majority in Wisconsin was an extreme conservative majority. And we're now going to see that become a liberal majority. So I expect you may see changes in a number of areas of jurisprudence in Wisconsin.
Now, ultimately, what could new maps mean for both the Wisconsin state legislature and the congressional delegation? Like, what? I guess, in the most conservative estimation and the most hopeful for Democrats' estimation, the most optimistic estimation, what could we see with new maps, both legislatively and congressionally?
Yeah. So look, the worst outcome is that the court says, you know what, this was ruled on last term. We're not taking this case up. We're not going to hear it. And that would be a shame because that would deprive the voters of Wisconsin fair maps and constitutional maps moving forward. So that would be the worst case. I'm hopeful that will not be the case, but we'll see. A middle ground would be that they say we're going to hear the case, and we agree we'll appoint some special master or some entity, some person to do hearings and fact finding, and then the legislature flips over time. In other words, they draw a new map. The entire state Senate is not up in 2024. Part are up in 2024. Part are up in future elections, and that you get sort of a slow roll of fairness. What the plaintiffs ask for, which I think is just brilliant on their part, and I think is exactly right, is that there are special elections in 2024 for those Senate seats. So essentially, the Republicans don't get the benefit of the bargain or the benefit of the gerrymander, I should say, in keeping those gerrymandered seats longer. If that's the case, I think you could see the legislature flip control after 2024. And if not flip, you'll at least see something that will look much more like 50-50. With respect to congressional, like I said, I think we wait to see how quickly this case moves and what they decide. But again, I think there would be time for 2024 if the Supreme Court decided it wanted to move expeditiously.
I know that you're not in the prediction business, but which one of those scenarios of the three, the most conservative, the middle ground, or the most optimistic for Democrats, do you expect will happen?
I learned a long time ago not to predict courts,
Yeah.
and I particularly am not going to predict this court. The new majority is sort of untested, right? It just became a liberal majority. I don't have a feel for kind of how they are going to view a number of these issues, which is probably appropriate. The courts need to do their business independently, and we'll see what they say.
Logistically speaking, how long do you anticipate this will take to litigate, including inevitable appeals?
Look, I don't think there's an inevitable appeal. This is the deal. This case has been brought in the highest court of Wisconsin.
Okay.
And unlike a potential congressional case, there's no basis for the Supreme Court, even under a fringe legal theory like ISL, Independent State Legislature theory, which was rejected. But when it comes to state legislative districting, the state Supreme Court is the final say. So one of the things that the plaintiffs did here in bringing this case directly to the state Supreme Court is to try to get them to rule on it directly. Now, if that's the case, this case will move very fast because there's no intermediate court. If we go to that middle option and it gets punted down to some, lower court to do fact finding or something, it could take months. If they decide to take this case themselves and decide it, I think we could have a ruling quicker than that.
So then do you anticipate, if they do take it up, that we'll have new maps in place for the 2024 election?
No question. I think that there is that if the state Supreme Court decides to take this case up, they'll do it with an eye towards giving relief. The one thing I want to say about the U.S. Supreme Court, which I oftentimes don't have a lot of good things to say about, is if you look at, for example, its decision in the Alabama redistricting case. Surprise to a lot of people, they upheld the need for a second majority minority district. The Supreme Court said that it expected that the lower court would draw a new map in time for 2024. It's only the summer of 2023. There is plenty of time in all of these cases, and certainly in Wisconsin, for the state Supreme Court to move this case so that voters do not suffer the indignity of voting under unconstitutional maps for another election.
All right, well, that seems like a good place to end there. And this is, one of those rare instances where we do have some good news to look forward to. So with that said, thank you to you and your team for the work that you do to protect voting rights across the country, including a number of cases in Wisconsin, even if not specifically this case. For anybody watching, if you want to help Marc and his team, then please sign up for Democracy Docket. It's a free news outlet focused on voting and elections. The link is right here on the screen. It's also in the post description of this video. I'm Brian Tyler Cohen.
I'm Marc Elias.
This is Democracy Watch.